What does this mean? What does this mean? Oh, let's get ready to break it all down. I'm Vinny Politan. Great to see you, folks. Big news, as you know, as you have heard, in the Karen Read case, a major motion filed by the defense. And I usually don't put those words together, major motion, because a lot of times it's just a bunch of malarkey. This is big. This, I think, is bigger than the Murdoch jury drama after that trial, which was huge in and of itself. So this is potentially enormous on many different levels. So here we go. Here we go. Wow. This is where we are. This is where we are. First of all, can everybody hear me? If you can hear me, let me know if you can hear me. I'm looking at my microphone. I don't know if it's working properly. Let me know if you can hear me. Can you hear me? Let me know if you can hear me. Also, by the way, folks, I was on assignment, busy over the holiday weekend, bouncing around to a few cities, filming more episodes of Accomplice to Murder. So that's where I was, in case you're wondering. Where'd Vinny go? Where was he? Where was he on Friday? Where was he on Monday? Where was he? That's where I was. Hope everybody's okay tonight. So, yeah, you know, I got these early yesterday while I was on the road. And I looked at him and I was like, oh my goodness. Oh my goodness. Oh my goodness. You know, different judges, different jurisdictions do this differently. You know, at Court TV, where I am, where I've been for years, longer than anyone else, I've seen juries all across the country and judges all across the country handle these situations differently. And as it was happening, we were talking about it. As it was happening, we were talking about, you know, what are the possibilities here? How is this going to go down? And I did raise the possibility at the time of a partial verdict, which is you reach a verdict on one count, but you're hung on the other counts. And overall, looking at what the defense is alleging here, and I'll get specifically into the papers in a second, but looking overall, what they're alleging is that this was a partial verdict. But the jury didn't know what to do, which shocked me, right? Because I was talking about this. Oh, this is like the smartest jury ever, right? The way they wrote these notes, etc. But they didn't really put the information in. If this is true, the note should have been different. I've seen it different in different jurisdictions, but they may have just been a little bit confused by the whole process. I don't know. I don't know what happened here. But as you know, the allegation here from the defense, from Alan Jackson and Dave Yannetti, is that they were contacted by members of the jury. Let me read for you. First, Alan Jackson's. On Tuesday, July 2nd, I was contacted by Juror A, true name and identity withheld to maintain anonymity. Smart. Based on my conversation with Juror A and that juror's description of who he, she is, where he, she was seated, and certain identifying information, name, occupation, disclosed during the voir dire process, I was able to positively identify which juror he or she was. So Alan Jackson is saying that, yeah, I was able to figure out exactly who this was. It wasn't some crank call, is what he's alleging here. Juror A told me that he or she was seeing inaccurate reports about the split among jurors related to the mistrial that the court declared the day before. So this is the next day. This is on the 2nd. Juror A stated that he or she wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of the process. Juror A indicated that she believes it's important to disclose such results because he or she believes that those results significantly impact Ms. Read's rights. Juror A told me that the result of the deliberations was that the jury unanimously agreed Karen Read is not guilty of count 1, second degree M, right? Juror A was emphatic that count 1, second degree M was off the table, and all 12 jurors were in agreement that she was not guilty of such crime, which jurors and juries have done this thousands of times. I would say dozens of times on Court TV through the years, where there are many counts and they can reach a verdict on certain counts, but are deadlocked on others. Partial verdict. I spoke about this. And that seems what was happening here. So, Juror A told me that shortly following that determination regarding count 1, the jury also unanimously agreed that Karen Read is not guilty of count 3, leaving the scene. Okay. That's 2 counts gone. According to this filing by Alan Jackson, this affidavit of Alan Jackson, which is a sworn statement, so he's swearing that he had this conversation. Counts 1 and 3, according to Juror A, who's remained anonymous, it was not guilty. Again, this is a partial verdict. 1 and 3 determined. 2, we can't quite figure it out. We can't agree. Count 2 is one with all the different choices, by the way. All the different choices. So let's further read. On July 1st, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. So what's happening here is that Alan Jackson in this part is declaring, listen, judge, you didn't give us a chance to have this jury questioned in open court. That's what he's saying here. This is an important fact he's alleging. Now, the judge is there as well, so she knows what happened. So he's saying, look, they sent the note, and then without any sort of conversation or asking either side, mistrial declared, boom, it's over. Neither Ms. Read nor her counsel consented to the entry of the mistrial. Again, this is important legally for appellate purposes. If the judge doesn't do something here, that they say, listen, we didn't have the opportunity. You know, defense attorneys always have to make a record. They have to object to everything. This is why sometimes it gets annoying in a courtroom, because if the defense doesn't bring up issues at the time of trial, even if they know they're going to lose those issues at the time of trial, they will be precluded many times from being able to allege or bring up that issue on appeal in front of another court. Well, you didn't say anything during the trial, so why should you get to say something now? Right? So that's kind of what that's what they're getting to here. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, on which count or counts the jury may have arrived at a verdict, saying you didn't give us a chance. Nor did the court on its own inquire of the jury foreperson on which counts the jury was at an impasse and whether the jury could or did reach unanimous agreement on any of the other counts. Had the court so inquired, it appears clear that not guilty verdicts would have been recorded for count 1 and 3. Ms. Read was denied her right to receive those verdicts in her favor. This gets back to, and I was saying this on this stream, I was saying it on television, how unfair my system of justice is to the jury. We already know how they sort of messed up the jury form and made it misleading. Like, these jurors are not lawyers. These jurors are not litigators. They're not criminal lawyers. They're not judges. They're not law clerks. They didn't go to law school. In law school, you don't even learn this, by the way. They are not practicing lawyers. So I think we, as our system, presume too much of the jury. And things like this can potentially happen when that happens. Now, first one to admit here, never practiced law in Massachusetts. I know the law is particular and specific on state to state. There are certain constitutional issues that override everything. Every state can have their own rules, regulations, and case law, as long as it's all within the purview of the United States Constitution, right? So the question is, were her constitutional rights violated here? Is this legal? What happens now? What on earth happens? Well, first, let's talk about how this happens. How this happens is we don't have conversations with the jury. Now, I have covered cases and trials on court TV in other jurisdictions, other states, other judges who have conversations at these points. Like, what are you stuck on? Sometimes they even ask for what the split is. Now, Massachusetts, my understanding is that's like hands off. You can't do that. You can't interfere with that. But now you're at the end and you're like, okay, well, all right, you reached an impasse. What does that mean? Here's the key question. Does the jury understand what that means? Does the jury understand it? Okay. Like I said, these are 12 people coming into a courtroom. Many times, first time they've ever even seen a trial. And many times, maybe the first time they've ever seen a criminal trial. They don't know the rules. They never served on a jury. They don't know what they can do, what they can't do. They don't even know, they may not even know what a deadlocked jury is. They may not know what a deadlocked jury is because it's not explained to them. Okay. Christine hasn't been following the story. Can someone give me the rundown? Don't believe she's guilty or innocent. Karen Read accused of running over her boyfriend. Contentious trial, 3 months long. She was claiming a conspiracy and cover-up. The overwhelming public reaction to this trial was not guilty. People at home watching the trial, listening to the testimony, seeing the evidence, coming to their conclusions. Obviously, in a slightly different position than members of the jury in the courtroom, but still getting the gist of what the case was about and what the defense was about. And overwhelmingly, the public reaction was, this is not guilty. In some counts, 87%. Some polls, I think local polls, had it at 75%. But then the jury came back and they deliberated for like 26 hours, and they said 3 times that they were deadlocked, that they were at an impasse. They could not reach a unanimous verdict. Some people felt it was proven beyond a reasonable doubt. Others felt the prosecution didn't meet their burden. So now, the day after, the defense attorneys are contacted, allegedly by members of the jury, saying, wait a minute. We did reach agreement on the top charge and the bottom charge, but not the middle charge. Middle charge was manslaughter, and there were 3 different versions of that. And then the top charge was the M. So, what does this mean? Okay. Well, let me read some more from you from Dave Yannetti. Okay. Another day, and this one's a little more complicated, right? Another day later, on July 3rd, attorney Yannetti, another one of Karen Read's attorneys, was contacted by 2 different individuals, hereinafter informant B and informant C, who had received information from 2 distinct jurors, hereinafter juror B and juror C, both of whom were part of the deliberating jury in this case. Informant B sent attorney Yannetti screenshots he or she received from someone here in intermediary B of text messages that intermediary B had received from juror B. Double hearsay already, like triple hearsay. But anyway, in that screenshot, juror B texted that following to intermediary B, it was not guilty on second degree, and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. Informant C had in contact with another individual, intermediary C, who was a coworker and friend of juror C, and joined a Zoom meeting during which juror C discussed the trial. Informant C sent attorney Yannetti the below screenshot of his or her text messages with intermediary C regarding what juror C revealed in the Zoom meeting. No consideration for murder 2, for M2. Okay. Well, that one's a little more removed, right? So it's the attorney getting a call from someone who got contacted by someone who allegedly was in contact with one of the alleged jurors. So a little more removed, to say the least, but somewhat consistent with what juror A, who allegedly directly contacted Alan Jackson, the other attorney, said. Okay, let's look at the big picture here. Okay. And there's going to be procedural rules. There's going to be all of that malarkey. But I like to take a big picture look at it, which is the Constitution of the United States, which has something called double jeopardy. Okay. Or a jeopardy clause, a violation of which is double jeopardy. You can't be tried for the same crime twice. Pretty simple. Which means if you're tried once and a jury returns a unanimous verdict of not guilty, you cannot be tried for that again. So the question here is there any way that the defense can turn this into a not guilty verdict? And if so, how do you do it? Can you turn this into a not guilty verdict? Well, the first place you're going to go is to the trial judge, Judge Cannoni herself. And that's who the motion's filed with, to listen to the allegations. So the allegations are in the paper, right? Then from the allegations, the judge has to make a decision. What do I do? Let's take a look at the Murdoch case. Allegations there made by the defense that the juror, there was some interference with the jury down there by the court clerk. So the judge brought jurors in and questioned them. Now, in that case, only the judge questioned the jurors. The parties were not permitted to do that, which I thought was an interesting approach to it. And it seemed like the judge in that case didn't want to try the case again and ask questions in a way that the judge would get the answers that she wanted or needed to confirm the conviction. We'll see what, if anything, happens to that on appeal. So what's the approach? It's the law, right? We're driven by the Constitution, by statutes, by court rules, and court precedent, right? In Massachusetts. So now you're asking the judge who oversaw all this, and you're telling the judge you messed up. That's what he's saying here. Like, your communication with the jury was messed up. You didn't ask the appropriate questions. You didn't allow us to ask the appropriate questions. You didn't do what you should have done to get from the jury what was really happening in that jury room. And you did not protect the constitutional rights of Karen Read in doing so. That's basically what they're alleging here, if you break it down. So I ask you this: what are the chances of the judge saying I messed up and allowing the defense to win this motion? What does human nature tell you? What does human nature tell you? Human nature tells me, right? I've been in the system. I'm just going to speak the truth of being in the system. That the law is open to some level of interpretation. Our Supreme Court, I'll go all the way to the top. Our Supreme Court, right? They get these big cases and they, based on the Constitution and precedent, they come to decisions. Yeah, right? That's not how they do it. That's how they're supposed to do it. But the way it really works, right now I'm taking you behind the curtain, folks, to give you a dose of reality. Now, lawyers who are still practicing likely don't say this and won't say this. But judges, and I'm not saying this judge, I'm saying all judges across the board, will look at a case and come to their conclusion on what their gut tells them. And then they come up with the supporting case law or precedent to support what they believe should be the outcome of the case. You follow me? So they get to their conclusions first, and then they back it up and how they can support that conclusion. That's just the way it works. And it starts with the folks at the Supreme Court. They get their cases, they read everything, they hear the arguments. In their mind, they know where they want to go. And then they've got some of the smartest law clerks in the country and saying, okay, what supports this? Go find it. That's how it works. You think it works differently at a trial for a trial judge, especially in a case where judge is part of the process that you are alleging is broken, right? Like, you're saying this was wrong. This was a mistake made at the end of a 3-month trial, judge. A mistake made by you. Now, the judge can just outright deny this. Number one, the judge will hear, I'm sure the judge will hear some oral argument on it, but the judge could just deny it outright. The judge could also not, hand them a not guilty verdict. That's never going to happen. That's never going to happen. Not here, not anywhere. I think the best the defense can expect here is if the judge opens the door to some sort of a hearing, opens the door for a hearing, and you bring the jurors in and you question them, not collectively, but one at a time to get their story on what happened here. And how that hearing is conducted may determine the results of that hearing. If they do it like they did in Murdoch, and the judge controls everything, and the judge asks the questions, and the judge elicits the answers, and the judge can use leading questions, the judge will get answers that will likely support the status quo, mistrial across the board. Now, if the lawyers are allowed to ask questions, you get a very unpredictable result because you don't know what these jurors are going to say. You just don't know. You don't know. You just don't know. That's much more unpredictable. I believe, though, if the judge opens it up to something that she controls, or in the alternative, like they did in Murdoch, you bring in a disinterested judge to hold the hearing. You can do that as well because you're alleging this judge messed up. I don't know if she would let go of it, but that's how you could maybe get one step closer to this. But as big and bold as this allegation is, right now it's still advantage or disadvantage defense. I think it's not, I wouldn't call it a long shot. I say it's about 70-30. About 70-30 that at this level, they can have this turned into a not guilty. Now, the other part of this is presuming that juror A is telling the truth about what happened in that court, in that jury room. We've heard from allegedly one and two of them through triple hearsay. So I take that with huge grain of salt. So tonight on my show, I think we're doing it in the second hour. I know we're doing it in the second hour. We're going to take a look at this issue of bringing our local attorneys. Bring in our local attorneys from Massachusetts who know the inner workings of the way that judiciary handles things, what the specific rules are there. Bottom line, this is a constitutional issue because you're talking about potential violation of double jeopardy, which is being charged or tried for the same thing twice. If the jury came back unanimous on the not guilty, it's over forever and ever and ever. Even if that jury comes back later and says, that's not what I said, Too late. Too late. So did the judge make a mistake? My guess is what the prosecution will argue is that the defense didn't say anything. These notes are coming back. Defense didn't ask for the jury to be polled. They could ask, but they didn't ask. If they don't ask, you don't get. You don't get, you're stuck. Boom, end of story. But maybe there's a lesson in all of this. The other lesson I want to point out on this is I've heard a couple of different takes here on what the numbers were. Like if it was 12-0 on 1, 12-0 on 3, and then some split in the middle. I've heard, we've heard anything from split down the middle to 9-3 not guilty. But there may have been some difference between which count, which lesser included of count 2 were they on. But to me, the takeaway is, number one, I knew this was confusing. But it's not just this trial and it's not just this judge, but it's our system of justice. Does not make things crystal clear for the jury when we send them off to do the most important thing, which is deliberate, which is to explain things to them. We don't let them know things. We should tell them, listen, specifically, you do this, this, and this. If you do this, then that. And when they come back, have a conversation with the jury. Have a conversation with the jury. But now the mistrial has been declared, so it's going to be difficult to undo that. But this is a constitutional issue. You wouldn't be able to undo it with a guilty. That would not happen. That would not happen, ladies and gentlemen. It just doesn't work that way. But defendants get the benefit here. They get the benefit of the appellate process in our system. Okay. So who's here? Melly's here, of course. Welcome, wonderful chatter. Sending you all good vibes. Vinny, we missed you. Can't wait to see new episodes of Accomplice to M. Thank you, Melly. And that's Sunday nights at 8 o'clock. I was filming 2 more episodes, which is why we are on talking about this today. Just got back into town. Melly, of course, one of our admins, our mod squad with Gen X and Frankie Figs. Thank you, Melly, on the job. Working hard for you, folks. Okay? Working hard for you. All right. Who else is here tonight? Lauren Katie, so many times they will agree on only one or more. This does happen. This is not unprecedented if this is the way they reach the verdict. But it's all about the... Okay, what's this? Vinny, why is your third mid-blacked? I'm not sure what that means, Jackie. Why is your third... Is someone blocked? Let me see something. Are you saying someone's blocked? What happened? All right. Here we go. All right. I don't know. I don't know, Jackie M. I don't know. I think everything's under control. Let's see where we are. Okay. Watching on YouTube. Stop by, says Mika, but commenting on Facebook, which is interesting. Interesting way to do it. Thank you so much. All right, here's Sherry saying the judge should be held responsible for this debacle of Vinny. Well, two things on that. Number one, these are allegations, right? These are allegations, and Alan Jackson is swearing to it, right? You don't do that lightly. You don't submit affidavits that you believe are false. So the question is was he being duped? And then the other question is this alleged juror A actually accurately reflecting what happened inside that jury room? It may very well be, but I don't think you can take this affidavit on its face, but I think it can be the means towards further investigation. But I agree, Sherry. I think I think there should be more communication at all times by all judges in all cases. I think we do too little to help jurors along the process. And when there's this much at stake, right? I know for judges across the country, it's just another trial. But for every individual involved in that trial, from jury to victim's family to defendant to families and friends, this is extremely serious, the most serious thing besides death that can happen. And for the victim's family, it does involve death. So this is as serious as it gets. So yes, ultimately, like anywhere else, the judge is in charge. The judge is in charge. The judge is the person who communicates directly with the jury. The judge is in charge of the entire case. The judge makes the rulings. The judge sets the tone. The judge makes the decisions. So in the end, if these 12 people all agreed that she was not guilty on 2 of these counts, then this is a major, major problem. Major problem. So we'll see where that goes. All right. Let's see. I will also say no judge wants a mistrial deadlock jury. They don't want it. But in this case, even if you allowed 2 not guilties, you're still going to have another trial by the prosecution, or at least they're entitled to try her again. So it doesn't get rid of the case. It doesn't get rid of the case. So we'll see how it works out. Sue Forte, Vinny, this crazy train is never going to run out of tracks. Yeah, exactly. A lot of things happen in this case that haven't happened in other cases, and it's only appropriate that we have something like this happen. See, what's interesting though, when you have cases that aren't high profile and something like this happens and it doesn't make the news, a juror won't hear news about misreporting of the split of the jury. The juror will just go home and no one will ever hear anything about it. Right? But in high profile cases, things are reported, things are discussed. And when you get to a case like this, I mean, you're getting into the weeds of everything. So that's where we are here. That's where we are. Lindsay, I want to address this. Lindsay Shea. Vinny, there should be qualifications to be a juror then, in my laugh out loud, in my opinion. Now, we can't have professional jurors. We want just regular folks. But what we need is regular folks who are told, who are given a little more information, and not even told the information once, but reiterated the information. And in this case, it's as simple as, and I've seen it done. Ladies and gentlemen, Julie, I got this note that you're stuck, and I just wanted to inquire how many of the counts have you reached an impasse? How many of the counts do you agree on? Don't tell me which ones or what this count is. Just let me know how many. Simple. It's really, if this is true, it is very, very unfortunate. If it's false, then it's going to even further undermine everyone's belief in the credibility of what's happening here. Frankie Figs saying, hey, Duty Ron. Duty Ron in the house. Make sure you subscribe to Duty Ron. Thank you, Frankie Figs, keeping law and order. Let's see. Now, Debbie B says, very unethical defense team. And you may believe that for a myriad of reasons, from statements to allegations made to conduct, etc. But on this particular issue, if Alan Jackson got that call and he did nothing, that would be unethical. And let me explain, Debbie. His ethical obligation is to his client and to his client solely. So if he has information that the jury reached a unanimous verdict that his client was not guilty and he said nothing and filed 0 papers, that's malpractice. That's unethical. That could get him fined. That could get him sued. That could get him suspended by the bar. That's how unethical that is. If you have information that could lead to the potential acquittal of your client and you sit on the information. So you can believe it, Debbie. You may be saying it based upon everything else that happened during the course of this trial. And people have very visceral reactions to the way the defense defended Karen Read here. So I understand that. But on this particular issue, it would be unethical for him or for them to do nothing. So I just wanted to clarify that for you. But thank you, Debbie. All right. Daisy Boo. Do you believe it all, though? Do you believe it all, though, Vinny? I think. Do you believe it all, though, Vinny? I think that's how it's read. I am not going to. I'm going to think that the hang up was on 2. That makes sense to me. That makes a ton of sense to me. But what I don't know is, did they take an actual vote on 1, or did they just move on to 2? Right? Did they actually say, we all agree, we're all voting? And if they did, why didn't they check that box? Why didn't they check the box? Or did they say, listen, there were some people who said, listen, I'll agree that it's not count 1, but we got to talk about count 2 here, which is more of a negotiation by one of the jurors, which is possible. That's why I need to hear from all 12. All 12. Like, this is the way Juror A was interpreting it, but don't forget how I started this. These jurors don't understand. Like, little subtle differences mean a lot. Like, if they all they voted and they all voted all not guilty and they all agreed, and that's one thing. If it's like, does anyone think, I think it could be 1, but let's talk about 2. And if we come something on 2, then I'm fine with 1 being a not guilty if we agree on 2. Right? That's a big difference, because that's a juror sort of negotiating with fellow jurors versus all of them agreeing and then moving on. If they agreed on count 1, then moved on to count 2, this is bad, like really bad. This is really bad. All right. Working through it, It's like I almost spin a wheel. There's so many comments. I sort of spin the wheel and then see where I land. What if? All right. All right. I just want to remind everyone, you are free to disagree with me and with each other. Just don't make it personal. No personal attacks. etc. As always, as always. Hmm. Gen X reminding us, don't forget, tonight, closing arguments, tonight, 8 o'clock. We'll be talking about this and the next big trial that started today, Alec Baldwin. Okay. By the way, next week I'll be out in Santa Fe, New Mexico for the Alec Baldwin trial. I should do some live streams from Santa Fe. We'll see if we can technologically get it going, but get ready for that next week. Here's a Glenda Mezzacapo, which means capo is head, mezza means half. Judge slanted, can she be replaced? Listen, no one's replacing the judge. However, Glenda, as I mentioned, it is possible, like they did in South Carolina in the Murdoch case with an issue like this, they could potentially bring in a different judge to rule on this particular issue and question the jurors. So that's a possibility. I don't think it's 100% necessary because it's a little different than in South Carolina. South Carolina involved the clerk of the court. So we'll see. A lot of great comments here. Mm-hmm. All right. Excuse me while I just read. This is like these conversations are amazing. All right. All right. A lot of interesting because we have the Tangent podcast in the chat tonight. There's a lot of tangents. People talking about the photographs that were put in the New York Post. People talking about a lot of things here. So I'm trying to stay focused here. I don't want to go off in a million different directions just because of time purposes. All right. Smile, everyone. McSpunky is here. Okay. We can relax. We can all have a good time and we can agree to disagree and agree to like and enjoy each other's company and each other's vigorous debate. McSpunky in the house. Daisy Boo with a super sticker. Thank you, Daisy Boo. Okay. Let me get to a few more here. All right. Mary says, Bev needs to talk to the foreman. Well, I think and you're right. I think you're 100% right. I agree, Mary. I think the judge needs to speak with every juror. If I'm the judge, I'm not a judge. My father was. But if I'm the judge, I bring them all in. Because ultimately, the responsibility of our system of justice is justice, which is the truth. And if the truth is, in this case, that this jury agreed, then okay, we need to, bring in this verdict in an unorthodox way, but bring it in nonetheless. If this jury, and I'm trying to figure out how this happens, like how do you reach a verdict on 2 of the counts and send a note that doesn't reference any of that we've reached an impasse? That's really frustrating to me. And again, we're basing this on quadruple or triple hearsay from 2 jurors and another juror, all anonymous, right? Haven't been named, but they shouldn't be named in the papers. But if this is true, this is where like the travesty of justice comes from. Because you try your case and you convince 12 people, which is hard to do. And if you're a defendant, it's extremely hard, right? It's extremely hard. And then you got to be tried for the same counts again. And, if those 2 counts get removed, the next trial becomes a much different trial. And we're going to talk about that tonight as well on Court TV. So I think it's important. It's significant. And it needs to be investigated, like thoroughly investigated. I know we don't like to do it. Our system hates it. We send the jury home. We want them to just move on with their lives. And we move on with whatever they said. But what if they didn't understand what they were saying? That's my concern. And it's always my concern. They don't know exactly what they're doing in there. Like if they thought they had to agree on all 3 counts, otherwise it's a deadlock, that's wrong. That's just plain wrong. And if they didn't understand that and they got that wrong, well, we need to right the wrong. It's a disaster. It's a disaster if you think about it, regardless of which side you are on this, by the way. But I will tell you, if it was the inverse, if it was 12-0 guilty at this point, you got to retry. You have to retry it. Again, because the way our system is set up constitutionally to protect the defendant. Mistrial declared, you're not going to bring the jury back and then find them guilty. That's not going to happen. But you might be able to, on a motion, have a judge enter a judgment of acquittal based upon this information after a hearing, sworn testimony by the jurors themselves. But if you bring them in, they may all have different stories. And my guess is the stories will all be slightly different. They always are. 12 people see the same thing. You're going to get at least 6 different versions of that, slightly different. The question is, how different will those 12 stories of what happened in that jury room be? But the only way you find out is by bringing them in. And I think you have to do it. Carolyn Smith saw a jury once that didn't understand unanimous, exposed when a judge asked if all agreed with the verdict and some said no. They got sent back to deliberate. Exactly. We have to make things extremely clear. And I'll be honest, I don't remember every word of the judge's instructions to the jury. Okay. And I don't have it in front of me. But man, oh man, I just know the confusion that takes place in those jury rooms time after time. And yeah, we trust a jury, but they're just supposed to find out, like determine what happened. And then we're supposed to spoon feed them the law. And the law is, if you've reached unanimity, is that what it is? I don't even know if that's a word. On 2 of the counts, those 2 counts have reached a verdict, and you can tell us. We did a trial where that happened, and 2 of the counts, they put it on the record, then sent the jury back to continue deliberating on the other one. But in all these cases that I've never seen anything like this. In the cases I've seen, the jury in their note will say, we agree on count 1, but we don't agree on count 2. But that didn't happen here. But it was such a great, incredibly well-written note, but it may have left out the most important part of the deliberations. If. What if? What juror A said is actually true and agreed upon. Ladia, you can't poll juror in Massachusetts. I think you can. I think you can poll them anywhere. We'll find out tonight, bringing in my Massachusetts attorneys. I'm bringing them in, Ladia, tonight in the second hour of my 2-hour show. Oh, here we go. All right. Linda, cute shirt, Vincent. Thank you, Linda. Cute dog, Linda. All right. Nick Rocco's with us. Weinberg is there for the juror issue at hand. He will deal with any appeals the defense will need for count 1 and 3. Good insight from our insider, Nick Rocco. Thank you, Nick. Foghorn Patty. Jackson is hoping for a Hail Mary. Not happening. See you on 9/22, Karen. I would agree that the odds are not in his favor, but I wouldn't call it a Hail Mary. To me, a Hail Mary is like you don't have a real basis for the argument you're making. You're just kind of throwing it up there. Not the spaghetti one where you're waiting for it to stick. But you're throwing something out there that is really a reach. Like we saw in Idaho, where they were trying to undermine the entire grand jury system in the state of Idaho. That was a Hail Mary. This isn't a Hail Mary. This is something different. It's a little less than a long shot, just a little less than a long shot, but not a Hail Mary. Like Hail Mary to me is woo all the way up here. Long shot is here. I think we're right about here. I think we're like 70-30 on this one. But there's a lot of things that need to happen. Like the judge needs to agree. Oh, this is a problem. The judge needs to agree. Let's bring in the jurors. Then you got to bring in the jurors. Then what the jurors say have to be consistent with what juror A is allegedly alleging. I love the allegedly alleging. Frankie Figs. Hey, McSpunster. All right. Oh, we've got a case on point. From Bushy Eyebrows. Look up Bluford versus Arkansas. Supreme Court case. Exact scenario. And what were the results, Bushy? You're burying the lead, kiddo. Is that dog staring at me? By the way, in my hand, folks, I think we discussed this before. The cherry plum. Is it cherry or is it a plum? Is it more cherry or more plum? I say it's more plum. That's a tangent. But Bushy Eyebrows. Yeah, blue. Let me look it up. Now, is that Supreme Court of Arkansas, or Arkansas as they call it in Kansas, or is it the Supreme Court of the United States? Got to look it up. I'm writing it down. Bluford versus Arkansas. All right. Thank you. By the way, folks, don't forget to hit the like button while you're here. Please hit the like button. And 1 second. Just checking an email from work. And I'm back. Hit the like button and subscribe. If you're on YouTube, Facebook, share it and subscribe. X, re-exit, follow. And on Twitch, you know what to do. Ben Mannion doing his analysis. The constitutional protection against double jeopardy is an interesting angle, but the defense is making a novel legal argument here with this motion. Feels to me it would be dismissed on a technicality. Ben Mannion, and that technicality could be, you didn't say anything when this was happening, Mr. Defense Attorney. Thanks, Ben. And Jake Green from overseas. Hey, Vinny, if lawyers had theme songs when entering the courtroom, what would be yours? Jake and Emma, your biggest fans in Wales, UK. Oh, let me think. If we had a walk-up music. All right. I'm going to attempt to play it, but I don't think you'll be able to hear it. It is a song. I don't know if you'll be able to hear it. Wait. Oh, I know where I can play it. I'll play it off of here. I just have to do this, okay, for Jake's sake. I'm sure you're all very, very on the edge of your seats on this one. This was it's not a lot of people know that this song exists. Oh, wait. This would be my theme song. I'm only gonna play a little bit of it because of all the, copyright, issues going along here, but it goes something like this. Alright, well, let me do this. You know what I'll do? I'll put it in the links. I'll let you listen to it at home. That'll be even better. That'll be even better. We'll put it in the links. Uh, Vinny, walk up music, and you guys can decide on your own. All right, I put it in there. You have to click on it, Jake. Great question, by the way. All right. Moto Goyo. I think Jackie means your shot framing means your face went behind the graphic a lot today. Who, me? Am I going down here? I got you. I'm here. I won't be down here. Thank you, Moto Goyo. Moto Goyo. And right now, how far behind am I? I am, oh, yeah, I'm a half hour behind. By the way, don't forget, 8 o'clock tonight, we'll be talking about this. I'm going to bring in some Massachusetts lawyers. I'm going to grill them. I'm going to ask them the questions that other people don't know to ask just because I've been doing what I've been doing for all these years. Captain Jenks, they will get the not guilty. You're not going to drag law enforcement through the mud in another trial. That's interesting, right? That's that, Captain Jenks does it like every time, Captain, you hit me with an angle that, like, wow. Now we know the initial reaction of Lally. But the question is, does do the state police, does everyone else want to move on from this? Now you still have the family of the victim who wants justice and believes, obviously, Karen Read is responsible. So don't dismiss that. I do understand the PR part of this, right? Well, they found this, this, and this. We only have the second count. What that also does, though, it opens up a sweetheart deal, a sweetheart offer by the state, Commonwealth. So Captain Jenks, you're definitely onto something there. That is an angle that cannot be dismissed easily. Lizzie B, never seen such a kangaroo court. I'm Australian. Slow clap for Lizzie B. Nailing it with the look on your face. You knew you nailed that. Good one. McSpunky. Hey, Vinny and all. Right at you, McSpunky. Right at you. Oh, this is interesting. All right. Calico 26. What if they told Bev and she kept it to herself? Another great angle. She did say she was going to speak to the jury. Now, this is interesting as well. If she has a conversation with the jury afterwards, she may be a witness, which means if you actually get a hearing, you would have to bring in a different judge to do it. If they had any discussion about the count or anything, she's a witness. That's a game changer. That's a game changer. What if they told her that they weren't unanimous on that? Oh man, more good questions tonight. My Massachusetts attorney. Write these down. Thank you, Calico 26. What if told the judge? That's huge. That's huge and all. I see. Let's see. By the way, folks, two really good episodes. I was filming on Friday and yesterday. Um, stay tuned for Sunday. Here is Michelle L. DY motion made further mention of count two misunderstanding, in my opinion, stating not guilty because KarenRead didn't cause the hypothermia. This jury needed help understanding and should have more clarity around the charges and instructions. Right? Mm, mm, mm. You know, to me, like the judge is constrained by what she can do based upon, the law and what you can and can't tell a jury on precedent, states, court, etc. Uh, we need this jury to understand what their job is. They need to communicate. We need to let them know that they can communicate if they don't understand it. We should encourage the question. I'll tell you something else great that's happening. It didn't happen here, obviously. But it actually happened in 30 days, where the jurors get to ask questions of the witnesses. To me, that that makes the verdict so much cleaner because the jury is getting the information that they actually want and need to reach a verdict. Sometimes there are things that don't get asked on either side, and it may be admissible. No one asks, and the jury wants to know. I believe the jury deserves to let them ask questions. Cheryl and Schaffner, we all wait a lifetime for cases this complicated. Oh, and it just gets more complicated. This makes it more complicated. The question is, what steps are taken to clarify what happened? By the way, over 5,000 watching right now. Thank you, folks, on this Tuesday. We so need Justice Toll on this case. Indeed. Indeed. Thank you, Daisy Boo. JH jury requested hard copies of instructions when sent back a second time. Also, if true, going to add to the conspiracy because the judge that picked the foreman. Right. All right. We're not getting audio? You having audio problems? Oh no, the audio is messed up. Is it better? Is it any better? Is it better? Is it better? No sound. 5,000 people and I have no sound. Muted. Am I muted still? Way better. Great. Ah, so sorry. I asked in the beginning because I saw a funny thing on my microphone. Is it still bad? Is it better? Is it still good? All right. I'm not going to touch it again. You should have heard what I was saying. It was so amazing. It was so amazing what you missed. Thank you, Amanda. Hard to hear me. Yeah. You know what it was? Gone all weekend. The gremlins come into the studio and they start messing things up. My audio gets weird. Da, 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 da. All right. Mott, go, yo, go. All right. I'm cutting up. Well, thank you, everyone, for sticking by me through the audio drama. Okay. All right. Thank you, Ramona. So I don't know where I left off. Did you hear the part about the cherry plum, which I'm going to eat right after this? It's be the last thing I eat today is going to be this cherry plum, which is definitely more plum than cherry. Oh, amazing. All right. All right. So I usually have my phone near me in case there's problems. Okay. All right. So I'm going to wrap it up for now. The reason I'm wrapping it up is number one, I've got some messages from work for tonight's show that I've got to deal with. And I'm almost out of time anyway. So big thank you. Good to be back. Again, I was gone over the holiday weekend, bouncing around, filming episodes of Accomplice to Murder. I got some good episodes coming up. So stay tuned for those. Sunday nights at 8. I'm on every night live, Monday through Friday at 8 o'clock, conveniently. Tonight, we'll be talking about this. We'll be talking about the Alec Baldwin case, and we'll be speaking about an incredibly happy ending to a very dramatic case, little baby Soraya. I don't know if you know baby Soraya out of Washington was abducted allegedly by her father and her father's fiance. They both went down to Mexico. They were looking for the fiance. She went missing. They're looking for the baby. Unbelievable. And so here we are. We'll be talking about that. We'll have the family on tonight on that. So I got a lot coming up tonight, 8 o'clock. 2 hours of live true crime on television on Court TV. No one else does it. Nobody else does it in the business. 2 hours unscripted, all the big stories on Court TV. Thank you to our mod squad getting it done. Thank you to you for all your support. Sorry about the audio issues, but we've got them fixed apparently, and I'm not going to touch them anymore. So I'll see you tonight, 8 o'clock on Court TV. Have a great night. And as always, please don't forget to hug the kids.